Welcome to On the Ballot with Ballotpedia, where we take a closer look at the top political stories of the day. Ballotpedia connects people to politics by providing neutral, nonpartisan, and reliable information on our government, how it works, and where it's headed. I'm Victoria Rose, and thanks for being with us. Last month, on January 17th, SCOTUS heard oral arguments in cases that deal with the National Marine Fisheries Service's interpretation of a federal fishery law. The court's ruling, one of the most anticipated in 2024, could affect future applications of Chevron Deference. What exactly does that even mean? So today we're going to jump in to Chevron Deference. It's been in the headlines a lot over the last few weeks. So we invited our chief policy editor, Caitlin Styrsky, onto the show to help break down the doctrine's history and how it works, the arguments for and against it, and what its future might look like after SCOTUS's likely ruling later this year. Caitlin, thanks for coming on the show.
Thanks for having me.
So this is our first conversation, first time having you on the podcast. So for our listeners, let's give them a background about you and your history with Ballotpedia. How long have you been with BP?
Great. I've been with Ballotpedia since 2015. I started as a staff writer on what was then our Influencers Project. We then started the Administrative State Project, which eventually grew into what is now our policy department. So I've had a few different roles at Ballotpedia, and I've kind of landed here as the chief policy editor.
Jumping into the topic at hand, what is the simplest way for our listeners to understand what Chevron Deference is?
So the big picture definition of Chevron Deference is that it's an administrative law principle that requires federal courts to defer to a federal agency's reasonable interpretation of an ambiguous or an unclear statute that Congress delegated to the agency to administer. Now, that's a bit of a mouthful. What exactly does that mean? So let's go ahead and break that down into some more bite-sized chunks. So Chevron Deference, it's an administrative law principle. So it's not a law in and of itself. What that means is that it's an accepted practice in the federal courts that stems from a legal precedent. And in this case, it comes from that 1984 Chevron case that we're going to be looking at a little closer during our time together here. And with that in mind, what does it then mean for a court to defer to an agency? Well, Chevron is a type of judicial deference, and in federal administrative law, deference, or the act of deferring, it means that a court accepts an agency's interpretation of a law or a statute, and it doesn't replace its own judgment with the agency's view. So the U.S. Supreme Court has developed several forms of deference over time to review agency actions. Chevron deference is probably the biggest, most well-known of these, but there's also Skidmore deference and Auer deference and several others. So what then do we mean by an ambiguous or an unclear statute? Well, Congress passes many, many laws, and a lot of these laws have kind of vague goals in mind, like, for example, achieving clean air or clean water. But putting these broader goals into practice requires some sort of agency action. So Congress isn't going to go in there and nitpick every tiny little action that needs to be taken in order to achieve clean air. They're going to tell the agency to kind of fill in the details by issuing some regulations to carry out those broader mandates. So that's kind of how the relationship between the law and the agency works. Then if there's any sort of statutory ambiguity or a lack of clarity in the law for how exactly the agency should proceed, that's what gives rise to Chevron deference. So when a group or an individual challenges the lawfulness of an agency regulation in court, the judges often use the Chevron framework to determine whether or not to uphold that regulation. And that framework itself kind of proceeds according to a two-step process. So in step one, the court is going to look at the statute in question, the law that the agency is tasked with administering, and it's going to determine whether or not Congress put forth a clear intent. And if it did, then the agency absolutely must carry out the express intent of Congress. There's no question about that. But if the court finds that the law is a little bit ambiguous, it's a little bit unclear, then they're going to look at whether or not the agency interpreted that law in a reasonable fashion. And if it is reasonable, if it's not arbitrary or capricious in some way, then the agency's regulations are then binding, and the court cannot substitute its own judgment for that of the agency under the Chevron framework. So hopefully that made sense, Victoria. If you need a little more information about that, we have a really great learning journey on this topic, and there's a link in the show notes.
That's a great plug, and that did make a lot of sense. I mean, I'm somewhat familiar working in the political sphere, but I think you broke it down really well for our listeners. Let's jump into this case that's before SCOTUS right now. Can you give us a snapshot of what the oral arguments were that were presented to SCOTUS last month?
Yes, so the oral argument was in this case Loper-Bright, and the case challenges the National Marine Fisheries Service's interpretation of a federal fishery law. That law is known as the Magnuson-Stevens Act, and it allows the use of compliance monitors on certain fishing boats. Well, the Fisheries Service interpreted the law as requiring fishermen to pay costs for the use of those compliance monitors. So a coalition of commercial fishermen appealed a ruling back in August 2022 from the D.C. Circuit that actually applied Chevron deference to uphold the Fisheries Service's interpretation of the law. The commercial fishermen didn't feel that the law required them to actually pay the costs for the use of those monitors. So while the federal law doesn't actually specify who must pay for the use of such monitors, the judges deferred to what they considered to be the agency's reasonable interpretation of the statute. And that interpretation did require the fishermen to pay the costs of those compliance monitors. As I mentioned, the fishermen appealed that decision to the Supreme Court. They argued that the statute isn't just unclear on the question, but also that it's just completely silent on the issue, meaning that Congress never actually intended to grant the agency the authority to force the fishermen to pay for those compliance monitors. They further argued that the court should reconsider its approach to Chevron deference by either clarifying how they apply it or perhaps even overruling it altogether. And that's exactly the question that the court decided to take up, whether the court should overrule Chevron deference or at least clarify whether statutory silence in cases like these function in the same way as statutory ambiguity, which requires deference.
We'll be hearing about the outcome of this case a little bit later in this year, but to add more context, let's take a look at that 1984 case that you mentioned in your introduction, Chevron USA versus Natural Resources Defense Council. What regulatory practice was Chevron pushing back against, and how did the outcome set a new precedent for federal regulatory activity?
Well, this case was really interesting because it really centered on the definition of a term that's used in the Clean Air Act, and that term is stationary source. So the Environmental Protection Agency issued a regulation that defined this term stationary source for the purposes of implementing the Clean Air Act. And under that regulation, the agency allowed states to treat all pollution-emitting devices within the same industrial grouping as though they were encased within a single bubble, and thus that was a stationary source for the purposes of interpreting the Clean Air Act. Well, the Natural Resources Defense Council sued the EPA and several companies in federal court over that interpretation of stationary source, and the D.C. Circuit actually set aside the agency's regulation. But then the Supreme Court came in and reversed that decision in favor of the agency, holding that the EPA's regulation was actually a permissible definition of the term stationary source, and that is what gave rise to what we now know as Chevron deference.
Got it. And this deference doctrine is almost 40 years old, I guess now. How commonly is it utilized, and has its influence declined over time or grown?
So to answer this question, I'm going to refer to a 2018 paper from administrative law scholar Michael Kagan. And he mentioned that Chevron deference had been cited 81,000 times as of 2018 in legal arguments since its first articulation back in 1984. And the doctrine was once supported by conservative-leaning legal authorities, including Justice Scalia and Justice Thomas. But Thomas, for instance, has in more recent years reversed his views. And we actually saw a reversal of views under the Trump administration, where administration officials were very open about the desire to nominate judicial appointees who were open to the idea of either overturning or limiting Chevron deference, or basically more broadly, the authority to have agencies interpret laws and enforce regulations without being subject to judicial oversight. But opposition to Chevron has actually materialized along a broader ideological spectrum. It's not just limited to conservative-leaning circles. According to that 2018 study by Michael Kagan, all 9 justices at the time had at least once signed on to an opinion holding that Chevron should not apply in a situation where an administrative law textbook would have said that it should be the case. So it's been interesting to see where those textbook cases of Chevron, where you would think that the doctrine would pop up, are not actually panning out in practice to fall along those lines. Kagan refers to this as sort of a period of uncertainty around Chevron. We're not really sure what the future holds for the doctrine, but that's why cases like Loper-Bright are so interesting for us, because they're going to shed light on Chevron's future.
You touched on this in this answer you just gave, but let's look at both sides of the argument and maybe more generally. What's the argument for keeping Chevron around?
The argument for keeping Chevron around comes from the point of view of the agencies. So Chevron allows agencies to operate in a really efficient manner. So that's kind of the first argument that you'll encounter. When the agencies have the leeway and the authority to interpret the statutes themselves and then issue the regulations that they deem appropriate, it allows them to operate in a more efficient manner rather than having a judge come in and tell them that they need to change their approach or change their regulatory framework. They have the broad authority under the Chevron approach to issue regulations that they deem appropriate. At the same time, the agencies are staffed with subject matter experts in their field. And that expertise is another argument for keeping Chevron around, because the framework allows these subject matter experts to issue regulations that are appropriate for carrying out some of these broad policy directives.
And on the flip side, what are the arguments for getting rid of it outright or alternatively weakening its power or narrowing its scope?
There's a couple of constitutional arguments that argue for getting rid of or limiting Chevron deference. The first of those arguments is the separation of powers. So Chevron deference, depending on who you talk to, of course, some people feel that Chevron deference allows agencies to interpret laws that should be the purview of judges under their Article 3 authority to interpret what the law is. So there's an argument that Chevron encroaches on the separation of powers because it's transferring that judicial authority to the agencies. There's also an argument that by delegating authority to the agencies to sort of fill in the details of those laws, as we discussed earlier, that they're actually violating the lawmaking authority of Congress. Congress is actually handing its lawmaking authority over to these agencies. So you have these agencies that are no longer functioning within the separation of powers. They're actually exercising lawmaking authority and judicial authority at the same time. So that's one argument for either getting rid of or eliminating Chevron. The other argument was kind of part and parcel of the former argument, but it's the view that the judges under Article 3 of the Constitution should have the authority to interpret the law and say what the law is. And when they defer to agencies, they're actually handing their judicial authority over to actors in agencies rather than exercising it themselves.
That's a great summary of the opposition arguments. As I mentioned in the beginning of our conversation, SCOTUS is likely to issue a ruling on Chevron deference later this year. Early reporting and much of the commentary is speculating that SCOTUS is either going to discard or narrow Chevron deference. So how might that affect the way federal regulation works? And of course, there's no guarantee that that's actually what will happen. So is there also a chance that Chevron will survive?
Well, first of all, this case isn't the first time that Chevron has been challenged. There's been a lot of discussion in recent years, a lot of speculation around whether this case or this other case might be the appropriate vehicle for the Supreme Court to narrow or overrule Chevron deference altogether. In fact, the American Hospital Association case back in 2021 was one of these cases where a lot of commentators really thought that it would provide the Supreme Court with an opportunity to limit Chevron deference. But surprisingly, the justices actually made no mention of the doctrine in the opinion, which led some analysts to think that the doctrine might just be shunned into oblivion. That's from James Romaser over at SCOTUS blog, rather than explicitly overturned. Because the court specifically will be addressing the question of whether or not they should overrule or limit Chevron, there's a lot of speculation at the moment that this will be the case where they actually do overturn the doctrine. To the second part of your question, there is a chance that Chevron survives, perhaps in a slightly different framework than exists at the moment, but the court may decide to narrow the parameters of Chevron to kind of trim around the edges, so to speak, rather than throw out the doctrine entirely. Depending on the way that the court rules, the effect on federal regulation could be very different. If the court were to throw out Chevron deference altogether, judges would be tasked with interpreting the law. They may or may not interpret the law in line with the way an agency interpreted the law, but that task would nonetheless fall to the judiciary. If SCOTUS narrows the doctrine, it remains to be seen how that would affect federal regulation. But we likely would see some sort of shift in agencies' approach to rulemaking and their approach to interpreting those statutes that they're tasked with administering.
Well, it'll definitely be interesting to see how the court ends up ruling on this, and we'll probably have you back on to explain the implications of that case when it comes down. But that's all the questions I have for you today, so thank you so much for your time, and thank you for coming on and explaining Chevron deference to us.
Thank you, Victoria. Thanks for having me.
And for our listeners, you can learn more about the Chevron Deference at the link in our show notes. We'll be back next week. Make sure you subscribe to On the Ballot wherever you listen to your podcasts. I'm Victoria Rose, and thanks for listening.